good to see we have a good turnout for this. I did have a college professor one time always start his very first class by announcing the wrong classroom so a bunch of people get up and leave, and he could have a workable group to work with that semester. And as for the questions and answers, when you submit in the questions, if you submit them through the app, then they should get to me. But I have to caution you, I am an attorney, so I don't answer questions. I just told a client a few minutes ago who said he'd been trying to read the new statutes that came out this last year, especially dealing with the constitutional carry provision and how that impacts local governments, and he said he just couldn't make sense of the law, and I said, well, that's because the law doesn't make sense. But the other part of that is, remember that there are no answers, there are only arguments. Lawyers, presumably the 9 best lawyers in the entire country serve on the United States Supreme Court, and they routinely disagree 5-4 is what the law is. So if you don't understand it, believe me, you're in very good company. How do I get this? Is this going to go up on the screen or the PowerPoint? I never start my presentations this way, but I have to do it this time. I have to apologize for this PowerPoint. This is likely to be the worst PowerPoint you've ever seen. It is basically just words on slides on the screen, and I didn't even put pictures of nuts and bolts up there, which I thought about doing, but I said, why make it look like it's going to be entertaining when there's just not any chance that's going to be true? I'm going to do my best to try and make it a little bit more entertainment in my presentation. I had a choice here, I thought, of presenting and trying to be entertaining with the slides and for this live group and for the live audience. But I also wanted to try and give you some tools to use. So in addition to this PowerPoint, which is the essentials summary of all the provisions in Chapter 36, I got 80 slides here in 45 minutes. In addition to that, I've also going to provide you all with a PDF version of Chapter 36 that is fully bookmarked. So if you're looking for a section, you'll be able to scroll down the menu, find it, click on it, it'll take you straight to that section. I think that'd be useful. I've always wanted one. I finally bit the bullet and got my assistant to spend a few hours doing that to the Chapter 36. And for the first time in a long time, there wasn't a single change to Chapter 36 this session, so we had a good document to work with. So starting with the nuts and bolts of Chapter 36, you have to look at the groundwater conservation districts in the state. Every colored in part of this map is a groundwater conservation district. There are 3 districts that deal with groundwater that are not governed by Chapter 36. That's the Harris-Galveston Subsidence District, obviously in Harris and Galveston counties, the Fort Bend Subsidence District in Fort Bend County, and the Edwards Aquifer Authority, which covers all or part of 8 counties centered around San Antonio. They have all now been completely removed from Chapter 36. They're not governed by or limited by Chapter 36 at all. One provision that's good, no one's going to be trying to amend 36 in order to fix a problem they had with either Subsidence District or the EAA. On the other side, it's kind of bad because those are the 3 biggest districts in the entire state in terms of both population and funding. And it'd be nice to have them on our side if we had a fight in Chapter 36 to help us defend it. So that's not going to be the case. But the rest of these districts are all governed in one way or another by Chapter 36. Having said that, this first caveat, my legal caveat here, remember that almost every one of these districts has its own enabling act, and that enabling act trumps whatever happens to be in Chapter 36. So everything that I'm telling you today, and I want to remind you, unless I'm your lawyer, I'm not your lawyer today. I'm not presenting this to be your lawyer or giving you direct legal advice. And everything that I tell you, please take it back to your lawyer and ask your lawyer what they think, because your lawyer is going to be the one that has to defend whatever decisions you make based on what you might hear here today. So, a bunch of districts across the state. This represents, I think the last time we checked, it was about 96% of all of the groundwater pumped in the state of Texas is pumped from within a groundwater conservation district. Gabe Collins was talking about those areas. And let me make this plea as well. The areas that don't have districts up on that map, those are unprotected areas. I'm not going to call them what you hear a lot of other people call them as white areas. They're unprotected areas. I think it's just very politically incorrect to try and say that. I think when these things are transcribed, it looks really, really bad on us to say the white areas of Texas don't need districts. those areas don't have a lot of groundwater and therefore probably don't need groundwater conservation districts. There may be a few areas that do. I would love to see a district in Lavaca County. I'd love to see a district in Valverde County. That doesn't look like it's going to happen anytime soon. Lavaca County had an opportunity and voted it down. That's their prerogative. I'm guessing someday when SAWS shows up with a couple of trucks looking for drill sites, they'll change their minds and there'll be a district created there. Valverde County, that's a tough one. I don't think they're going to get a district until they petition TCEQ to come create one for them. So we'll have to see what happens there, but the rest of the state is pretty well covered, and I think we generally do a very good job. I think the lack of litigation over what we do is a great indication of how well we work with our constituencies and what a great job we're doing in doing the least we have to do the maximum amount of protection that we need to do. But I have to tell you folks, the times are changing. Every district out there, I think, is going to be challenged one way or another as we see things continue to develop. My last political statement that I'm going to make here, well, probably not, but the last one I'm thinking of right now is this impetus on groundwater production and groundwater development started with Senate Bill 1 in 1997. And what started it was a provision added to that bill that makes it created a junior right provision for surface water transfers between basins. So if there's an interbasin transfer of surface water, the water that gets transferred automatically becomes junior in priority to every other permit on that surface water system, which means there haven't been any. Why would anybody go buy a junior right? There's no point to it. And because of that, we've seen all of the development since 1997 has almost all been directed straight at groundwater and groundwater conservation district areas. And that's why it has become so contentious, because we've become the supplier for the entire state for new supplies. So let's talk about Chapter 36. Starting off with some basic groundwater law. I know all of you probably already know this, but I want to really quick touch on it. Groundwater is any water found percolating beneath the earth. However, based on Chapter 11, it doesn't include the underground stream or underflow of rivers. Now, I have to tell you, in Texas, I don't believe we've ever found any place that has the underflow of a river. It doesn't start until you get to the New Mexico border. And then everything pumped in New Mexico is the underflow of some river. I've had a couple of situations where I thought we were dealing with wells that were very close to a surface water stream and therefore probably into the alluvial sands and the underflow of the river. And I've contacted TCEQ and said, I really think this is your problem, not my problem. And they said, no, it's your problem. So that may be changing now with this lawsuit with New Mexico, but we'll see. It does not include any water withdrawn from the ground that then later enters a state water course. One of the many other decisions that came out of the Day case that nobody talks about, the Day and McDaniel well was a free-flowing artesian well. The water came out of that well and went into a surface water stream, an intermittent stream that then was captured behind a soil and conservation dam, and they pumped the water from that dam out to irrigate their fields. And the moment that water left their well and crossed over the bed and bank boundary into that surface water stream, it became surface water that belonged to the state of Texas. So everything that they pumped out of that dam, out of that little reservoir, to irrigate their fields and their pastures was not groundwater. It was all state water, which is why they didn't get a permit for any of those fields they irrigated from that area, because it wasn't irrigated with groundwater. I also going to talk about waste a little bit about too. I think that there's going to be some big arguments over the question of waste. So what is out in those unprotected areas, what rule applies, and actually what rule still applies within the groundwater conservation districts in terms of liability between properties? It's called the rule of capture. Your neighbor, I always started off by saying, you get to pump as much water as you want to without regard to the damage you do to your neighbor, and everybody would say, that's a great rule. I like that rule. I've changed that now, and I say, no, this means that your neighbor gets to pump as much as they want to without any regard to how much damage they do to your well. That's a terrible rule. Why would anybody have that rule? So that's exactly what the rule of capture is. It's a rule of non-liability. It says that you are not liable for any damages you may do to your neighbor, and they're not liable to you for any damages they do to you. That's essentially the Texas court system saying, not our problem. And legislature, you need to handle this. The last time they said that was the 1997 case of the Cipriano case, also called the Ozarka case, which reiterated the rule of capture. And tellingly, in that case, there was a concurring opinion by now Chief Justice Nathan Hecht that said, we are keeping the rule of capture for now. If the legislature doesn't start taking care of this problem across this state, then we will step in and change that rule and have to start doing something to prevent the harms otherwise allowed by the rule of capture. The legislature has responded to that. We've gone from 47 districts at that time, I think, now to 100. And you can see by the map I had up there a moment ago just how much they have reacted to that. And now it's our job as groundwater conservation districts to take care and prevent the harms that would otherwise be allowed by the rule of capture. I want to point out too that the court said, the rule of capture said nothing at all about ownership. They went 9 pages through all the history of all the groundwater cases and said in not one of these cases did we say anything at all about ownership. And then at the bottom of page 9 they said, but we do so today. And the ruling there was that every landowner owns, as part of the realty, the groundwater in place before capture. See, prior to that, the rule of capture absolutely said you had absolute ownership of everything you pumped. But that's kind of, they call that the bucket strategy. Once it's in your bucket, you own it. Before it's in your bucket, it's anybody's game. Anybody can take it. Same rule that you have for wild animals. When a wild animal wanders onto your property, that you can capture, shoot, pin up that wild animal as much as you want to. If it wanders off your property, then your neighbor can do it. And other than that, it doesn't really belong to anybody. Same thing applied to oil and gas for a while, same thing applied to groundwater up until this 2012 case. The court also said, however, that unquestionably, the state is empowered to regulate groundwater production and said, quote, regulation is essential to its conservation and use. So they recognized the need for groundwater conservation districts and the absolute desire to have them do a job, again, to prevent the harms otherwise allowed by the rule of capture. But that regulation cannot go so far as to cause a taking of private property. I'm not really going to get into takings today. We're going to concentrate on Chapter 36 and kind of go over everything that's there. Here's how the chapter is organized. Starts off with the general provisions. That's mainly the definitions. I want to kind of go through a couple of important definitions there. How districts are created, how they're administered, what their powers and duties are, how they're financed, the fact that we can issue bonds and notes. Does anybody here know of a single district that has issued a bond or a note? I guess districts have borrowed money at different times, but they haven't really issued notes. And I don't believe we've ever issued any bonds. But we have that authority if we ever need to. Now, if you're going to go build a building, if you're going to build an office building, if you're going to go certainly build a recharge structure or some other type of water supply, bonding authority might be important to that, but as far as I know, no one's ever used it. The district revenue section is there, the judicial review, then performance review and dissolution. That's an important one to understand exactly how that works. We do have the ability to add territory to districts, and we have the ability through subchapter K of consolidating districts. And then we also have, believe it or not, there's a groundwater conservation district loan fund at TWDB where we can go borrow money that's aimed at brand new districts or trying to get up and going. It's hard to get a district going when you have no money to do so. A lot of them have gotten money from their local counties, but if you're a multi-county district, that's hard to do. So now there's for some time now, there's been a water development board fund available to do that. Subchapter M directs us on what we do and how we respond to permit and permit amendment applications, all the notice and hearing requirements. And then finally, subchapter N deals with aquifer storage and recovery projects and how that might impact groundwater regulation. So let's get into the definitions. Statutorily, we have defined groundwater as water percolating below the surface of the earth. Remember, Chapter 11 puts a kind of caveat on that dealing with underflow of rivers. That's not in the definition in Chapter 36. The definition of waste, producing groundwater if the water produced is not used for a beneficial purpose. So if you're not using the water beneficially, that's considered to be waste. Well, we're going to see in a minute how that may not matter because of the definition of beneficial use. But this next one is going to be a hot topic, I think, in several different parts of the state. Willfully or negligently causing, suffering, or allowing groundwater to escape into any river, creek, natural water course, depression, lake, yada, 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 yada. or onto any land other than that of the owner of the well, unless such discharge is authorized by a permit, rule, or order issued by the TCEQ under Chapter 26 of the Water Code. Chapter 26 is the wastewater discharge permit chapter. So if you're going to be discharging waste into a river, even though that started out as groundwater, if you do so according to a permit, that's not going to be considered waste of that groundwater. Now that's put there because these utilities didn't want to have they pump the groundwater up, they run it through their system, they recapture it as wastewater, they treat it, and they discharge it to the surface water stream. They didn't want someone fighting their waste discharge permit saying that's a waste of groundwater by discharging it, therefore you cannot discharge any water into the stream. So they put that exception into that definition of waste. Beneficial purpose means a bunch of things: agricultural, gardening, domestic, stock raising, exploring for, producing, handling, and treating oil and gas. C, or any other purpose that is useful and beneficial to the user. That makes our jobs kind of difficult. It's kind of hard to say that somebody wasted something by not beneficially using it when the user gets to define what's beneficial to that user. So we haven't seen a lot of cases on waste in Texas. There's also another famous case, Pleasanton versus Corpus Christi, that made it hard to waste water by putting it into a river. That definition of waste was changed after that case, so I think that may trump that old Supreme Court case. But until we have another lawsuit, we're not really going to know that for sure. But it's hard not to beneficially use it as long as I feel like what I'm doing is beneficial. So if I've got water out in a nice, what I like to call vanity ponds, or I want to have fountains, or I want to have a creek flowing through my property and I'm pumping groundwater to keep that creek flowing, I'm not sure that's not a beneficial use. And certainly I can tell you this, the developers all around the Houston area that have put in what they call wet detention ponds, where they have a detention area for stormwater and they keep some water in it so it looks nice all the time and they can grow some plants around it and it looks really nice. Those wet detention ponds are extremely useful to those subdivisions. The Subsidence District about 5 years ago proposed a new rule that said all of the wells that are currently providing water into those lakes, as long as the well is there, we're going to continue to permit the well, but we're not going to issue any new permits for any new wells to do that from this point forward. And the developers showed up and basically said, you've taken my firstborn child, this is a horrible thing, we can't possibly live with this rule, so the Subsidence District did not end up adopting that rule. So what is beneficial and what is not looks apparently to be in the eye of the beholder. General provisions on the purpose. I think this is important. There's actually two sections that discuss the purpose. Provide for the conservation, preservation, protection, recharging, and prevention of waste of groundwater and groundwater reservoirs or their subdivisions, and to control subsidence. That is one of the strongest environmental laws we have in the entire state of Texas. I mean, that is very, very broad authority for what it is that you're here to do as a groundwater conservation district. Then later on, it says we're also the state's preferred method. I'm not sure what other methods there are. I guess home rule cities can adopt certain rules dealing with wells and things. For the preferred method of groundwater management, in order to protect property rights, balance the conservation and development of groundwater to meet the needs of the state, and use the best available science in the conservation and development of groundwater. Then we jump over to 36.116 of the Water Code to say another place where it says what our purpose is: to minimize, as far as practicable, the drawdown of the water table or the reduction of artesian pressure, to control subsidence, to prevent interference between wells, to prevent degradation of water quality, to prevent waste. A district rule may regulate the spacing of water wells or the production of groundwater. So the rules that we can adopt are directly related to that same purpose. We're here to preserve, conserve, protect the aquifers and the groundwater in those aquifers. There's also a section in this here that talks about groundwater ownership, 36002. The legislature recognizes, that's a brilliant statement, the legislature recognizes. I don't have any idea what legal authority that grants, but at least we know they recognize it when they see it. Groundwater below the surface of the landowner's land is real property. But then they have subsection D, and this is extremely important. This section does not prohibit a district from limiting or prohibiting the drilling of a well by a landowner for failure or inability to comply with the minimum well spacing or tract size requirements adopted by the district. It does not affect the ability of a district to regulate groundwater production as authorized by these sections or otherwise under this chapter or their special law. Nor does it require a rule adopted by a district allocating to each landowner a proportionate share of available groundwater for production from the aquifer based on the number of acres owned by the landowner. That last one deals directly with what American law across the entire United States calls a correlative right. The right you have correlates directly to the amount of land that you own. Now, there are places where that may be very appropriate. There are districts that have adopted rules that are very close to correlative rights. There are a number of districts that have adopted what I would call a correlative cap that says you may pump as much as you can put to a beneficial use as long as you don't exceed X number of acre feet per acre or X number of inches per acre of production. But we're not required to. There's nothing in this ownership question that says we have to do it that way. We have litigation going on right now in federal district court that's basically arguing, yes, you do. The only way that you can have equal protection under the law, and that we'll see how that finally ends up. But the argument is you cannot have equal protection between the landowners unless you treat every landowner exactly the same, meaning every landowner gets to pump exactly the same amount of water from that aquifer. And we're going to have to see what happens with that litigation to tell you whether or not they're going to prevail on that argument or not. And here's the hardest part about that. If we do have to do that, if we have to say that ownership of X number of acres is the only way you can get a correlating amount of groundwater, what does that do to the utilities, the large industry, the very big irrigators? Because they're the ones that have the investment-backed expectations. They're the ones that have invested in treatment systems, pipelines, storage, in order to be able to produce X amount of groundwater. And if we tell them now they're going to have to go out and buy a bunch of groundwater rights from their customers in order to be able to continue producing that amount, I think we're going to see takings lawsuits against the Groundwater Conservation District for making that argument or adopting that rule. And frankly, if I've got to have a fight between a utility that's got millions of dollars invested in being able to produce X amount of water and a landowner that has 10,000 acres but has never drilled a well, I'm going to pick the fight against the 10,000 acres because he's going to have a much harder time proving those investment-backed expectations over what we saw from the utility. The one taking case that has prevailed in the state was somebody that had invested in pecan trees and the ability to be able to provide water to those pecan trees. And essentially, the value of that land as a pecan farm, they were able to claim and successfully proved in court was going to be damaged as a result of, I'm going to say, not say the district's, because it wasn't the district's fault, it was the legislature's fault. The legislature's rules as to how much water they were entitled to get. So, how are districts created? There's a couple of ways to create them. Legislation is the most popular. Almost all the districts have been created by some sort of legislation. Or you can petition TCEQ to create a district. Since at least 2003 or 2005, I can't remember which, county can no longer create a groundwater conservation district. It's kind of questionable whether they could before. A few districts were created by their county commissioner's court. I believe those districts have since been ratified by the legislature in other legislation. But clearly now only TCEQ can create a district by petition, but the legislature, of course, can do whatever they want. If that district to be created is inside a priority groundwater management area, or PGMA, that district doesn't need a confirmation election. It's automatically created. Now, if they want to do taxes, I'm getting ahead of myself. Outside a priority groundwater management area, any district that's created does have to have a confirmation election. Now, inside both of those types, if you want to do a property tax to fund the district, then you have to have a tax authorization election. I have no time left. Interesting thing on the creation of the district, each separate county may opt out of the district. Cities may not opt out of the district. If there's a multi-county district and one county votes against it, that county ends up not having a groundwater conservation district. Cities don't get that that choice. You do have to have a director's election to replace the temporary directors with newly elected directors. Yeah. That one? Oh. Okay, it's not going. There we go. This one?
Right there. That second bullet, cities may not opt out?
No. Now, the legislation, there are several what I call donut districts, where the district was created and includes everything except within the city limits of a particular city. That's the legislature doing that. What the opt-out part is if there's an election and everybody in the county votes to approve the district, but the people inside the city vote against it, that doesn't mean the city is not part of the district. If you have 2 counties or 3 counties that are all voting at the same time, and 2 vote to create the district and the third one does not, those 2 create a district. That third county is not part of the district. I think it's in Brush Country, a legislatively created district? Yeah, the legislature created it that way. So again, your individual legislation can do all kinds of things that 36 wouldn't allow. So it's always possible that your individual act says something different than 36 that would allow the city to opt out of being in the district at its own choice. But under 36, that's not an option. So if you're going to create a district, you want to give the city that option, the Enabling Act has to say that. Activity following the elections start with research, then to plans, then to rules, then to permits, then to enforcement. What does everybody talk about when that bill is going through the legislature? How much is my permit going to be? That's putting the cart before the horse. We don't know how much your permit's going to be until we have the information necessary to decide how much permits everybody's going to be. And frankly, that was the #1 problem we had with the Edwards Aquifer Authority and the reason we had a $4.5 million judgment because of the Bragg pecan farms. If the law hadn't told the district exactly how much water everybody was entitled to get, we could have handled the Bragg's issues. Unfortunately, it did. The administration, I'm just going to fly through all the administrative stuff because I am running out of time very, very quickly. Okay, I'm looking, it says 2 o'clock, so I got 15 minutes, right? Okay. I'm going to jump into the powers and duties section here real quick. Let me get to this part right here. Suits against districts. A district may be sued in any state court. The directors are immune from suit except for conflicts of interest, abuse of office, or constitutional violations. So unlike every other political subdivision in the state of Texas, your directors cannot be sued personally unless there are one of these 3 specific allegations being made. A district shall not be required to give bond for appeal, injunction, or cost in any suit, and a district shall recover its attorney's fees, costs for expert witness, and other costs incurred by the district before the court on any issue in which the district prevails. So this is a big advantage for groundwater conservation districts. It has helped lead to very few lawsuits. There are those out there, the Farm Bureau is kind of taking the lead on this, saying that this is unfair, this is wrong, we need to change it. Senator Perry very strongly feels that it ought to be a level playing field. It ought to be, in fact, his original bill was a loser pays bill that said that if whichever side prevails should be able to get their attorney's fees. Okay, yeah, let's say you've got somebody who is on the board and they have their own farm apply for a permit and that board member votes to grant that permit to himself. That's a direct conflict of interest. You could have the same thing if it's within a certain degree of constant, I'm going to get the words wrong, familial relationship with certain family relationship there. That if you're doing things that benefit your brother or brother-in-law through the votes on the board, that's a conflict of interest. Chapter 171 of the Local Government Code provides very specific examples of what is a conflict of interest and what you have to do. If you have a conflict, you have to abstain from voting. Now, please note, when you're talking about a permit being issued, that can lead to a direct conflict. If you're talking about adopting a rule, it's very hard for a rule to lead to a direct conflict. So the rule, if it applies to everybody the same, you get to vote on that. But your permit, which is going to grant you a specific amount of water, you do not get to vote on that. That's a conflict of interest.
One other question is the directors are immune from suit.
Mhm.
In the 2019 summit, we were encouraged by some attorney, I don't remember who it was, to have directors and officers liability insurance. Can you give us your input on that?
I'm a big believer in insurance. I think the question was, because of this provision, is it still important to have errors and omissions policies for directors? I'm a big believer in insurance. I think we ought to have insurance, and there are always going to be cases that might fit into one of these situations where the insurance is important to have. But make absolutely certain that your insurance policy actually covers you. I found a number of policies out there that say, well, we will provide you errors and omissions service coverage except for the following exceptions, and then it accepts everything can possibly happen. So, right. Well, but they're both kind of the same category, just to make sure it actually, that the exceptions don't wipe out the rule and don't wipe out your coverage. Both the TWCA Risk Management Fund and TML have very good policies that deal with those questions, but there's a lot of other private policies I've seen out there that really don't provide any coverage. Okay, powers and duties. There's a whole list here in 36 subchapter D talking about what you can and cannot do. When you're making rules, you have to consider all the groundwater uses and needs. You have to develop rules that are fair and impartial. I have no idea what that means. That's not a legal standard. We've never had it tested, so I don't know. There's no way, until it gets tested, I can't tell you what the impact of that is. You have to consider groundwater ownership and rights. You have to consider the public interest in conserving, preserving, protecting, again, the same list we had from our purposes. Consider the goals developed as part of your management plan, and not discriminate between land that's irrigated for production and land that's part of an irrigation suspension program by the feds. You can do enforcement of your rules through negotiated settlements, filing a lawsuit for an injunction against further action, seeking civil penalties up to $10,000 per day per violation, or the penalty schedule set by the board. Now, that penalty schedule set by the board, some people I respect have argued that creates what's called an administrative penalty, where the board can simply say, you're going to be fined $20,000 for that activity. I'm not sure it kind of goes that far. The Administrative Procedures Act that allows for administrative penalties for state agencies is 3 pages long. This is 1 sentence. So I'm not sure a court's going to see that as giving us that authority. However, if you want to hold a hearing and conduct a hearing and have them come and make their case, and at the end of that hearing you say, we find that there has been a violation, and you can settle that violation by paying a $20,000 fine, and if you don't, we're then going to sue you in court in order for you to come up, and that's going to be up to $10,000 per day. That would be the way I would approach that. I would call that a settlement as opposed to an administrative penalty, and then I think you're going to be just fine. And having that hearing may be beneficial when you get to the district court level. Part of what you have to do is put together your plans. You have to gather data, take surveys, do research, have monitoring wells. You're authorized to do well registrations and pumping reports, and in fact, you're required to do well registrations. The statute says the district rules shall require all wells to be registered. Now, why is that important? It's extremely important in the enforcement context. The exemptions are based on how you use the water. And if you're not there watching how they use the water, how can you swear in court they didn't use the water for domestic and livestock? They actually were using the water for this industrial use over here, or selling it for oil and gas use or some other non-exempt use. If you're not there every single day checking on it, how many days they violated that part of the statute? If they have failed to register their well, every day that the well is there, that it's not registered, is another violation up to $10,000 per day. And that is a huge advantage, again, for the groundwater conservation districts. It's easy to see. The well went in this date. It was never registered from this date to this date. That's this many number of days. Now, the statute says $0 to $10,000, so it's still up to the judge if they want to do a $1 penalty or a $100 penalty or a $1,000 a day penalty. But it usually is enough to bring people to the table and get them to negotiate a settlement and to stop violating the rules. The management plans have to be done and there's a couple of parts of this, because of different parts of the code, I want you to understand what this is. Your first management plan has to be approved within 3 years of creation of the district. You have to get approval for your plan, reapproval for your plan every 5 years, thank you. And within 2 years after adopting a desired future condition, you have to amend your plan and resubmit it for approval by TWDB. That section doesn't appear in the powers and duties section. That's in 363011B5, where it says when the people go to petition TCEQ, that if you haven't amended your plan within those 2 years, then you're in violation of that part of the statute. Here's a whole list here of all the district's powers and duties and for the management plan's goals, providing most efficient use of groundwater, and everything down to and addressing the desired future condition adopted by the district. Then we have the joint planning area. We've all gone through joint planning. We've all been part of the desired future condition process. The state's divided up into groundwater management areas. They're based on groundwater reservoir and political subdivision boundaries. The objective of that is the most suitable area for groundwater management. This is what those areas look like. The Caruso-Wilcox formations divided into 3 separate groundwater management areas. The Gulf Coast Aquifer divided up into 3 separate ones. The Edwards Aquifer is pretty much all one area. The Trinity is kind of divided between 2 areas up there. The Panhandle and the Ogallala is divided into 3 separate areas. Those are set up by the Water Development Board. And that's what you have there to work with for your joint planning. I'm sure you already know that the panel's made up of the GC presidents or the people that they appoint, and their job is to establish desired future conditions. That is the condition the aquifer is going to look like 50 years from now. And that's a policy-based decision, not a pure science-based decision. You can say, we think it's okay to have 500 feet of drawdown, or you can say it's not okay to have more than 5 feet of drawdown. Both of those are acceptable. In fact, there's a number of different desired future conditions that you can adopt. You have to consider a bunch of things there: the aquifer use conditions, the hydrologic conditions, the environmental impacts. You must consider the impact on subsidence, the socioeconomic impact, the private property rights, the feasibility of achieving it, and any other relevant information you can come up with. But it must provide a balance between the highest practicable level of groundwater production and the conservation, preservation, protecting, recharging, and prevention of waste of groundwater, control of subsidence in the management area. So it's got to be a balance between those things. Here are the types of desired future conditions we've seen. Sustainable yield, the amount that can be produced indefinitely. No more than X feet of drawdown over that 50-year period. Maintaining spring flow, making sure there are gaining streams. Or maintaining spring flow during drought periods. Both of those are valid. Not causing any subsidence. Those are all valid desired future conditions. I'm not going to go through the process. You have to have the explanatory report, which is extremely important. And at the end of that process, the district shall adopt their desired future conditions. Now, appeal can be filed. I hope you've all heard my discussion about the appeal process. Instead of making my argument again, I'll quote Marty Jones in a presentation he gave at the Water Law Conference, where he said the appeal process turns a 5-year planning process into an 8-year planning process, which I think makes it fairly useless. I'm going to jump ahead here to the judicial appeal. The judicial appeals of district decisions are based on what's called the substantial evidence rule. That means that whatever decision you've made has to be substantiated through evidence. There has to be some evidence there to say that this was the correct thing to do, or that we made the right decision on that rule or that permit. That substantial evidence rule is another huge advantage to the groundwater conservation districts. The other side has to prove there was no evidence to support the decision you made. Now that means if you grant a permit and you had some evidence to justify the level of that permit, the court should uphold that decision. If you deny that permit and there was no evidence that would support the granting of the permit, the court should uphold that decision. If you deny a permit, but there was some evidence that it should have been granted, well, now you're probably in trouble. If you grant a permit and there's no evidence to support the amount that now you're in trouble. But any substantial evidence, and substantial means more than a mere scintilla of evidence, will support the decision made by the Groundwater Conservation District. Huge advantage for the districts.
Greg, is the last bullet on the slide you had there, has that ever happened?
No, we've never had a DFC appeal get all the way up to the court level. It's never happened. So the last bullet is there, it's in the law, it's never happened. Yes, sir.
So on the last bullet, when the court does strike a DFC, which happens what happens then?
When did the court strike your DFC?
It found our DFC unreasonable and unenforceable.
A court did that, or the TWDB did that?
Court did it.
I'm not even familiar with that case. I'll have to look it up.
The Mark Corkle found the rule, the DFC, unenforceable and unreasonable, and struck it.
Okay, I know that he found, okay, that the DFC, you're talking about Lone Star Groundwater Conservation District. The DFC was by agreement between the district and the petitioners, was found to be no longer reasonable. And so that DFC came off the books. All that caused a problem with the management plan later on. What Judge McCorkle ruled.
Judge McCorkle ruled it's unreasonable, then the appeal was filed, and then the groundwater district dropped the appeal.
Right. My understanding that appeal was on the rules of the district, not on the DFC.
No, it's on the DFC.
Okay. I'll go take another look at it. But yeah. What's supposed to happen is the whole process starts over again. You kick it back to the GMA. The GMA has to adopt a new. That's a great question. That is a great question. Since we do this every 5 years, it's hard to get to that point when you're not already in the middle of starting the next process of adopting the next DFC. Well, we tried to get that fixed legislatively. My suggestion is that you put some DFC in your management plan, because without a DFC, you're not going to get TWDB to approve it. And that would mean either continue to use the one that's been declared unreasonable as part of your management plan, or go back to the one that was adopted prior to that, which is now 10 years old.
You cannot use the one that's been deemed unreasonable because you just got sued and just got beat. You're going to get sued again? So my question
I understand.
what do you do?
That's a great question. We tried to fix that legislatively this last session. We didn't get there. So the entire appeal, trust me on this, the entire appeal process for DFCs, I think, is a complete mess. When you're doing something every 5 years, you should put all of your effort and time into fixing whatever problem you have with that next round of planning 5 years from now. You're going to have a whole lot more success doing that than you are trying to fix the one you adopted that's going to be gone by the time you get through this process. So I apologize for not going to be able to get through the whole presentation. Yes, sir.
Does the TWDB have the right to set your DFC once it's been deemed unreasonable?
No, the TWB has no authority to set or decide a desired future condition at all.
Really?
They have the ability to say, your plan does not meet the requirements and we're not going to approve your plan. That they can do.
But can they say go back to your last DFC and put that in?
I don't, well,
Do they have the right to do that?
I don't think that they do, but I have to tell you, if they're not going to approve your plan, it's going to be real hard for you to force them to approve your plan, even if they're doing it for a reason that they don't have a right to do. It's just it's going to be, again, that's going to add another 3 years of litigation on top of what you've already gone through. So anyway, you have the entire presentation. You'll have that there to look at, plus the Chapter 36, bookmark Chapter 36. I appreciate your time and attention, and apologize I went over my time.
Any more questions for Greg? One more chance.
Yes.
How about in terms of Street Valley, 2011, and you bust your DFC, how do you prepare that?
Okay, great question. What happens during drought years and you're going beyond your MAG, your model available groundwater that you can produce? That's 1 year out of 50 years of production. Now, if your goal, your DFC is constant spring flow, and the springs dry up, you probably have violated your DFC in that 1 year. But if you don't have that, if you have, we don't want to have more than X amount of drawdown, and 1 year it gets drawn down below that, and the next year it recovers, I think you're going to be just fine. Okay. Thank you very much.
Let's give